The International Center for Settlement of Investment Disputes, otherwise known as ICSID, made headlines last year when it ordered Pakistan to pay $5.9 billion in damages to Tethian Copper Company over the denial of a mining lease in Reko Diq, Balochistan. Since the judgment, the Pakistani government's poor management of the Reko Diq case has been widely reported. What is less well known, however, is that ICSID and other such investor-state dispute settlement or ISDS institutions have many flaws of their own and often fail to act as fair arbiters of justice. So, as with most things, there are two sides to this story. Soch explains the Reko Diq case, Part 2. The goal of ICSID, created by the World Bank in 1966, and other ISDS mechanisms is, in the words of the ICSID Convention's preamble, international cooperation for economic development. While 163 countries, including most developed countries, are signatories to ICSID, it was created primarily to promote foreign investment in developing countries. Foreign investors could be assured of a fair and neutral referee when investing in developing countries, while their increased confidence would mean more foreign investment in developing countries. Practically, however, it hasn't quite worked out like that. Multinational companies have filed lawsuits or used the threat of filing lawsuits in arbitration bodies such as ICSID to get away with questionable practices all over the developing world. From Indonesia in 2004, where the government wanted to ban open-pit mining in protected forests, but allegedly, under threat of international arbitration, granted exemptions to 12 mining companies. To El Salvador in 2009, where the threat of a $70 million lawsuit gave the government no choice but to settle against a factory that allegedly poisoned villagers with lead waste. To South Africa in 2010, where Italian mining investors challenged a new law attempting to make amends for apartheid by mandating that 26% of all mining companies must be owned by black South Africans. The investors eventually dropped their ICSID case only after the government agreed to water down their required commitment to 5%. The use of this practice has especially skyrocketed in the last 2 decades, with developing countries being targeted disproportionately. What was once a rarely used worst-case option has become a threat, and ever more frequently by powerful corporations which, unlike many developing countries, can hire the best lawyers in the business. In the nearly 1,000 cases argued in arbitration, reportedly only 2 were filed by countries, Gabon and Romania. The rest were all corporations. In fact, some law firms specializing in ISDS cases now actively hunt for investors that are willing to fund promising lawsuits in return for a share of the eventual award. They constantly monitor changes in a country's rules or laws which could harm foreign investors and thus open up an opportunity for a potentially lucrative lawsuit. At the heart of the problem lies the fact that companies defend themselves in front of arbitrators who often belong to the same cluster of corporate lawyers that represent big corporations in other ISDS cases. So lawyers can literally go from being an arbitrator one day to lead counsel for a company the next. One of the 3 arbitrators in the TCC case, for example, Claus Sachs, has served as the lead counsel for corporations in multiple domestic and international arbitration proceedings over a career spanning decades. This circle of elite ISDS practitioners also manifests itself in cases in other kinds of ways. Another one of the arbitrators in the TCC case, Stanimir Alexandrov, used the same expert brought forward by TCC to justify their exorbitant damages claim in another ISDS case, where Alexandrov was serving as a party's lead counsel, Bear Creek versus Peru. ICSID's decisions are also not subject to external judicial review or effective public scrutiny, and they are not bound by any judicial precedent except their own. This combination of factors has led to unfathomable rulings such as in the Reko Diq case, where ICSID determined that TCC's owners were owed $5.9 billion for a mining project that had been purchased in 2006 for a mere $170 million and had received investment worth only $200 million and had never even begun operations. The fine, worth roughly 2% of Pakistan's entire GDP, will in turn have to be paid back by Pakistani taxpayers who had no knowledge of the deal to begin with and whose consent was never asked for by the caretaker provincial government that signed the deal in dodgy circumstances in 1993. The methodology ICSID used to determine the size of the award was also questionable, as it was based on TCC's argument that it had the right to receive from Pakistan the full present discounted value of all future profits from this non-existent project, using notoriously unreliable and fluctuation-prone future prices of gold and copper, calculated for 56 years of hypothetical operations. To that end, the ICSID tribunal made several assumptions, each of which was problematic at best. First, ICSID arbitrarily decided that TCC would have received an automatic renewal of the proposed 30-year mining lease, contrary to the position of the provincial and federal governments. Second, that TCC would have received a 15-year tax holiday, despite no evidence of such a proposal. Third, that they would have been paid below mandatory statutory royalty rates, despite any such agreement. And fourth, that environmental standards would have been met, despite the project requiring vast amounts of water in an area with extreme water stress. Unfortunately, once a tribunal decision is handed down by ICSID, countries like Pakistan can only file for a revision or annulment of a decision, not an appeal. An annulment only assesses the tribunal's decision from a narrow criteria of procedural issues, rather than an appeal, which would have a broader scope to consider whether the tribunal simply got the decision wrong. This has led to widespread calls for reform from influential voices all across the political spectrum, ranging from the conservative US Supreme Court Justice John Roberts to the left-wing politician Elizabeth Warren. Unfortunately for Pakistan, it is likely to find itself in many similar situations in the future. International tribunals such as ICSID usually gain jurisdiction over cases through bilateral investment treaty, or BITs, such as the Australia-Pakistan Bilateral Investment Treaty in this case, since TCC as an entity is registered in Australia. And Pakistan has a lot of BITs. Starting with signing the world's first ever BIT with Germany in 1959, over the years Pakistan has signed 48 BITs with various countries, 35 of which was signed between 1988 and 1999. It wasn't until the country got sued by a Swiss company under the Switzerland-Pakistan BIT in 2001 that the government finally slowed down in signing BITs. That lawsuit was eventually decided in Pakistan's favor, thanks to our then Attorney General Makhdoom Ali Khan, who later admitted in a 2009 interview that diplomats had considered BITs to be good photo opportunities without any consequences, and that the first he ever heard of them was when he Googled ICSID and BIT after the filing of the Swiss lawsuit in 2001. Ironically, Makhdoom Ali Khan, too, would go on to serve as both counsel and arbitrator in ICSID proceedings. The government of Pakistan has now faced 10 different lawsuits in international arbitration in the last 2 decades, 2 of which led to damages being awarded against it. Tethian Copper versus Pakistan, $5.9 billion, Khaki Karadeniz versus Pakistan, $800 million, although it has now reportedly settled the case for $165 million. Yet another case, Al-Tawarki versus Pakistan, was filed in 2018. But unlike various other countries such as Ecuador and South Africa that have terminated their existing BITs, or countries such as Venezuela, Bolivia, and Nicaragua that have withdrawn from ICSID, the government of Pakistan has taken no steps so far to axe its BITs, or even come up with a policy to deal with such exposure. Even if Pakistan decided to terminate its currently signed BITs, the agreements usually have sunset clauses that take many years into the future before they can actually expire. Additionally, since developing countries such as Pakistan often suffer from corruption and lack of investment, they are unlikely to be able to attract many foreign investors without agreeing to ICSID arbitration to begin with. So what alternative does Pakistan actually have to safeguard its interests in the future? The answer may lie with our next-door neighbors. In 2017, India not only ended 58 existing BITs, it also prepared a model BIT that severely restricts a foreign investor's right to initiate international arbitration without first exhausting local remedies. On the other side of the world, the new agreement between the US, Canada, and Mexico also has similar provisions while also narrowing down the jurisdiction of ISDS cases. Another possible model could be the EU's proposal to create a multilateral investment court to resolve foreign investment disputes rather than ICSID and other arbitral tribunals. Unlike the tribunals which are constituted on a case-by-case basis keeping in mind a single BIT, the EU court would have a permanent roster of judges, having much stronger conflict of interest rules, an appeals process, and consistency in its rulings across all bilateral agreements. In sum, there is no question that BITs and ISDS mechanisms undoubtedly need to be reformed. But in the meantime, the government of Pakistan has to address one unavoidable fact. It must finally start negotiating deals on the basis of public interest rather than private gain.